The next several minutes, we're going to talk about some additional legal and regulatory issues, including the Children's Television Act, 1990, political advertising, libel, and privacy. We'll start with Children's Television Act, 1990, and essentially what this regulatory piece of legislation has done is it requires television stations, broadcast TV stations, to really broadcast in the public interest by meeting the needs of children through informational educational programming. The act itself put a cap on the number of commercials that you could have in a television show within a half hour, within an hour. And it also said that you have to provide a minimum of 3 hours of kids programming per week. Kids programming for many stations or educational programming had been categorized in ways that maybe weren't so educational. Example being if, say they were showing the Flintstones, perhaps you've seen the Flintstones, an old school cartoon, the stations would argue that the Flintstones was teaching history, therefore it was educational. So on some levels that's somewhat laughable, but you know, that's what the broadcasters wanted to do because more people tuned into the Flintstones than they would a documentary about the Bedrock Age or the Stone Age. Another example would be showing the cartoon The Jetsons, which is about the future and flying cars and folding briefcases that fold from a car into a briefcase. So those things were used. Let me switch over to a different screen so that you can see a few more details about this. So take a second. Hopefully it'll work for me. If we arrive here, I have a cat that's helping me out. I have on my Springsteen hat since it's Springsteen's birthday. I'm going to find this other slide for you. And apparently it is working. Get back to the right screen. It is presenting that to everyone. And then click over so that I can scroll through. Here we go. So the children's TV programming, again, puts that limits on the kids' programming. 6 minutes during the weekdays, 5 minutes for the weekends per half hour. So that means 12 minutes within a full hour of commercial time. So within 1 hour, no more than 12 minutes of commercials can be shown during the weekdays. And on the weekends, when typically more kids are in the audience, you can only show 5 minutes in a half-hour program, obviously 10 minutes in a full hour's programming. Another piece of the puzzle that you want to be sure you're familiar with is that the, just checking to make sure it's showing, that the commercial and the program itself are separated. So if you've ever seen those, we'll be back after these messages that pop up and they have a little icon or a little cartoon character looking caricature image up there that says there's a break in the program, we're going to go into commercial. That's so that it helps little kids know that there's a separation between advertisements and commercials. Another piece is program length commercials were banned. That means we can't show a program about G.I. Joe and then break for a commercial that is a commercial for G.I. Joe. So those things were not acceptable. And as noted, we have to serve, broadcasters have to serve in the informational and educational needs of kids, and it's 3 hours a week minimum as shown on the other slides. So that's a quick synopsis of the Children's TV Act, and some key pieces about the limits on the number of commercials, the number of hours per week of educational programming, and Also, the ban on the programming commercials and the separation needed between commercials and programs. So I'll shift back. Hopefully this will work for us, and bring up another set of slides. I'm going to share again, and let's move on to, go back to this other set of slides and move on to the next piece. Give me a second. Sorry, there's too many windows up. Let's talk a little bit about copyright. This is kind of apropos. Just perhaps today, really learned last night that Happy Birthday, the song Happy Birthday, actually will now be in the public domain. For years and years and years, it was owned by what had been Warner Brothers, Warner Music Group, Warner Chappell Music Publishing, and the judges just recently ruled that Happy Birthday is acceptable in the public domain. So no longer, if you work at the restaurants, do you have to sing the crazy little birthday tunes that Red Lobster and Logan's made up with the yeehaws. You get to sing the actual Happy Birthday because it is public domain, meaning that the copyright has expired. So let's take just a minute or two to talk about copyright. It does protect intellectual and aesthetic property. The idea in your head can't be copyrighted, but once you put it in a fixed, tangible means of expression, I like to say a fixed, tangible medium. And here are examples of what's tangible: records, vinyl, films, TV, computer programs, scripts. Those things are tangible media and tangible means of expression, and those can be copyrighted. The notes that you take and you share that you've interpreted, that technically can be copyrighted. So so that's what we're looking at. So anything that you do create, you can copyright. Here's a note. I don't like the way this is written, but what I want you to know is that copyright protection lasts for the life of the author plus 70 years, the 70 right here. Obviously, if it's created after 1978. The way that it's termed here, it makes it look like the 50 is the primary, but because 1978 is quite a while, many years ago now, please know copyright is the life of the author plus 70 years. If you get that question on the test, you need to choose life of the author plus 70 years. So that's a long time. Say that you do live 75 years old, then it's 70 more years before copyright goes in the public domain. So that's important to know. Scanning up and down, looking here. Note that there is a doctrine of fair use, where in an educational setting, you can copy a few pages, or we can play some snippets of a movie, or we can play the whole movie in an educational setting to critique it and to be scholars that interpret what's saying and analyze it. So fair use is often claimed when people are sued for copyright infringement. They'll say, I have the legal right to use it fairly, i.e. in these contexts. So be sure to look up the 4 tenets of fair use: purpose of the work, the amount of the work used, are 2 of them, the nature of the work. Here's a quick example on fair use. If you are in a classroom and you have a workbook, say it's a math workbook, and you do the assignments inside the workbook, you work out the problems and you turn those in for homework. Well, those are then considered consumable pages. If the professor copies the pages and hands those out to you and you don't have to pay for them, that's a violation of copyright. That's copyright infringement because the professor has taken away the opportunity to earn money, essentially, for that creator of the workbook. So the effect on the market, that's one of the 4 tenets of fair use. Effect on the market is really the one that's the big stickler. Is someone losing money? Is someone losing money? So please review that and be familiar. Copyright protection comes, full protection comes from the Copyright Office in Washington, D.C., and you actually have registered with the Copyright Office. Registered. The fee these days, it used to be $35, but I think it's gone up. Anything that you create from the moment it's put into a fixed tangible medium is copyrighted, even without the copyright symbol. So says the Berne Convention, B-E-R-N-E, Berne Convention from 1989. But in a court of law, to be fully protected, you are going to have a better shot at winning your case if you are registered with the Copyright Office. So oftentimes you'll see people who will post their materials, post their work, photography, and they will put a copyright notice on it so that there's no question whose that is. And of course, anytime that someone uses your work, you're entitled to royalty payments. People can make a lot of money if they know how to police those who are infringing upon copyright. Just a few more comments here. Music licensing has organizations like ASCAP, BMI, and CSAC that work in as representatives of the artists, so that the artists don't have to constantly police and ask people for money to use their material. So a radio station will pay ASCAP, BMI, CSAC to get rights. Usually it's ASCAP and BMI in the United States. Will pay the rights to play the music on their radio station. The University of West Georgia pays the ASCAP and BMI licensing fees so we can play music at the football games, so we can play music on the Wolf. If you don't have those licensing organizations granting rights to you, you can pay a lot of money if you illegally use someone's music. So the blanket rights are allowed, as noted here, and then ASCAP, BMI, CSAC distribute money to the publishers and composers. Just a couple more pieces here. Again, it protects intellectual property and the fixed tangible medium. Once it's copyrighted, you have the right to authorize derivatives. And derivatives can mean, say you do a song and then you want the dance version. You can authorize that. Say that you do create a TV show character and you want to have a bobblehead. That's a derivative. And again, this slide is reviewing the European and then the American music licensing organizations. Not sure why that slide is there. That's a repeat. Moving forward, the Digital Millennium Copyright Act, the DMCA, you cannot create measures to circumvent measures that control access to copyright works. So you can't create something that is going to allow you to basically steal someone's work. Internet service providers are protected against copyright infringement because they only transmit. Sorry, don't know why that came up. They only transmit information. They are not the originators of it. If AOL puts out something that is directly from them, then that's a different story. Internet radio stations too must pay licensing fees. You see down here. That would be sound exchange. So the Wolf pays sound exchange. I think it's $600 total to deal with the licensing fees, so that every song we play on the Wolf will get money to the artist. And I believe that's important. That if you're going to be an artist, you're going to create those things, you need to have your work paid for, or need to get paid for the work that you do. All right, we're moving along. This may be a little bit lengthier than perhaps we all like, but I do want to highlight these. What we're going to deal with, just doing a preview: obscenity, indecency, profanity. Again, this machine is acting foolish. There are differences. It's just the bottom line, the differences between obscenity, indecency, profanity. Talks about the criminal code. The FCC can't censor broadcast content. However, in Miller v. California, court case from 1973, where Marvin Miller sent pamphlets through the mail that had depictions of people in sexual positions. He was brought up on charges, and from that particular case, the definition of obscenity was developed. And it said that if the material appeals to the prurient interest, just a little too into obscene material, things that just seemed are of a sexual nature, then that is one tenet of obscenity. The real big piece of the puzzle is that obscenity, obscene material, lacks serious artistic value. The LAPS, L-A-P-S, literary, artistic, political, and scientific value. Lacks literary, artistic, political, and scientific value. The LAPS value. So someone who may have created a pornographic film may claim that it is art because maybe there's a really interesting and creative lighting or set design. Or maybe there is a literary reference because at the beginning someone is reciting Julius Caesar or Hamlet's soliloquy. So there's a ways to get around it. But broadcast, as well as cable, as well as even print materials, obscene material is not covered by the First Amendment. And they just have some other pieces of the puzzle here. They're saying that there's XXX films, one version for cable, another for theatrical and DVD release. And so that kind of highlights things on obscenity. Indecency, though, which begins to start here, is different. Indecency, indecent material can appear on broadcast, whether it's radio or television, after the hours of 10 p.m. So 10 p.m. to 6 a.m. is a safe harbor. This all stemmed from the George Carlin, it's actually the 7 filthy words case, often referred to as the 7 dirty words, where he listed out 7 words that you can't say in broadcast. Someone played that. A father heard that in the car with his teenage son, listened to the whole thing, and then complained to the FCC. And from that, the FCC developed indecency standards that said you can't air this material that may impact children in a negative way, except during the hours of 10 p.m. to 6 a.m., assuming most kids are in the bed, sleeping. So these, just following through here, these are some other slides you can read through about indecency and obscenity that kind of detail more about it. Trying to find the other piece of the puzzle here. Give me half a second. Okay, unavailable for the moment, and that is fine. We will move on. Trying to get back to the screen, and I am here. There are obviously attempts to regulate the internet because of the amount of indecent material that's out there. The bottom line, in 1997, the Communications Decency Act in Reno versus ACLU, 1997, said that the rules of the CDA, as you see here, are unconstitutional. So this Communications Decency Act was ruled unconstitutional by the Supreme Court, and in the end, the internet has the same protection as books, magazines, newspapers, same protection as print. It's very, very key. Congress continues to try and put forth other legislation that will protect kids, but oftentimes it infringes on the First Amendment. As it says here, Congress has not found a way to protect kids from internet obscenity and also protect the free speech of adults. That's the real issue. Sure, we want to protect kids, but too often the laws are overbroad and they reach too far into free speech for adults. Moving forward. So that ties up obscenity, indecency. They are different. One has a national community standard, indecency, obscenity with local community standards. And note that pornography may be obscene, likely is indecent, but obscenity and pornography are not the same thing. Just to go back and say that. We will move on to highlight some of the laws of broadcast involved in broadcast journalism. Defamation. Here you have this. Double checking the screen is up. It is. Defamation. You're protecting your reputation. This is libel. This is when you make a statement that ridicules, brings scorn upon, lowers someone's standard in their community. The erroneous stories, the stories that aren't true, essentially, or that put someone in a bad light. Example, you're calling someone a drug dealer. That's usually not going to be a good thing for them. So libel is very serious, and it's a type of defamation. Slander, you may have heard of that. That's spoken word, whereas libel is in a tangible medium, i.e. broadcast, print, etc. Be very, very wary of libel. As a journalist, you may get yourself in big trouble. So defamation is not something that you want to do in your journalism career. There are 5 things you must prove to win a defamation case, typically a libel case. They include defamation. Was someone harmed? Was it broadcast or published is what it's called. Was there identification? And was there fault by the people who were broadcasting or writing it? And is it false? So the easiest way to remember: defamation, publication, identification, fault, and falsity. So one more time: defamation, publication, identification, fault, and falsity. Those are the best ways to remember it. Fault, relate that to actual malice. Did someone knowingly publish something false, or did they have a reckless disregard for the truth? That's for public figures. Carelessness or negligence is for private citizens. So you can follow up on that in your other materials. How do you protect yourself if you're sued for libel? You can say that there's the truth. I printed the truth. That will stand up. I may have privilege or immunity. Here it's saying the public's right to know versus reputation. But the privilege could be that you have a reporter's privilege. You simply are stating something that happened on the floor of the Congress in which someone defamed another, but you are simply reporting what happened in an official proceeding of the legislature. We also have fair comment or criticism, where you can make comments that may be libelous, but it's an acceptable acceptable comment because you are criticizing, as it says here, public officials are subject to both these, and it does not entitle the press to report lies. But we may be critiquing someone's work in office and attempt to tease that out to figure out if it's really true or not. As I noted before, malice, plaintiff must prove actual malice if they're a public figure or a public official. That was established in New York Times v. Sullivan in 1964. For the sake of time, we'll move forward. Invasion of privacy. There's 4 areas of privacy that you see down here, 4 areas. It's publication of private facts. So that's you have a yellow toe and you don't want anyone to know about it. You have an eating disorder and you don't want anyone to know about it. Those are types of private facts. Arthur Ashe had the fact that he was HIV positive from a blood transfusion was a private fact that he didn't want out there, but he ended up having to reveal that because a USA Today reporter was going to write a story about it. Intrusion is the only one that's about gathering information, whereas the others actually have publication involved. False light is the one most closely associated with defamation, but it's considered an invasion of privacy. You put someone in a false light. And then the one that is most common is this commercial exploitation. It's known as appropriation, and that's where you use someone's image without their permission. Note here, privacy law differs in many states, just like libel and defamation. And the goal is to be free of intrusions and unwarranted publicity. And so we thus have these different privacy laws. For the sake of time, I think I will switch over to the political advertising and then tie things up. So let me double check where I am. I'm going to have to change my screen and click back quickly to this and make sure I'm sharing. Hopefully everyone can see the political advertising. Just briefly, there are 2 key sections of the Communications Act of 1934, Section 315 and then Section 312. 315 deals with the equal opportunity rule, the equal opportunity rule. This applies to all political candidates, whether it's for dog catcher, for President of the United States, for governor. So the equal opportunity rule. It's not equal time, it's equal opportunity. Let's see if I can explain it to you. Give me just a second. Equal opportunity is, apologize, I'll find it in just a second. Equal opportunity, just want to make sure I have this right for you. All political candidates can use broadcast stations if they ask to have time on a station. So if I come to a TV station, WABC, and say, I'd like 5 minutes to talk to the country on your station, if the station says, yes, I will sell you time, then anyone else who comes to the station and asks for time must be afforded the same opportunity. The same opportunity. It doesn't have to be exact same time, 5 minutes, 6 minutes, 8 minutes, but it has to be the same opportunity. So if it's prime time, in which the candidate gets the window on the station, then candidate A, and when candidate B comes, they can't be put at 3 a.m. They have to be put in prime time as well. So Section 315, equal opportunity. We check out, sorry, I clicked the wrong thing. We check out the, once again, I'm trying to find it. Sorry, guys. And I've lost it. Okay, so section 312 is slightly different, and it applies to federal candidates only. Give me just a second to find what I need. Sorry, guys. It has disappeared. Okay. I am attempting to find, I have lost it, and I truly apologize. Let me see if I can make it work here. And we should get it here in just a second. I think I found it. I found it, yes. Okay, so we should be going on to the exceptions. Exceptions for the section 315. If a candidate appears in a newscast, candidate A appears in a newscast, candidate B cannot claim equal opportunity, because that's just part of the everyday press. If they're in debates, one can't claim that candidate A got more time than candidate B, because it's an exception to the rule. Make note also that in section 315, you cannot censor ads. You cannot censor ads. So things that may be highly offensive to people cannot be censored. All right, 312, very quickly, reasonable access. The other was equal opportunity. This is called reasonable access, section 312. You see here, it's all federal candidates. Here's the deal. Stations have to try to accommodate all requests. Stations have to try to accommodate all requests. So that means if a station, someone is running for office, for the president, Senate, presidency, Senate, vice president, and they come to a station and say, I'd like 5 minutes, then the station should make it accessible to the candidate by providing the time. The station must make it accessible to the candidate by providing the time. So that means that vice president candidate 1, 2, 3, and 4, if they all come, the station must do its best to require time. All right. With that, I think we've gone probably past our time. I leave up these last 2 slides about section 315. You can read through those. If you have questions, let me know. Otherwise, we have survived with some trend. The legal and regulatory pieces of the puzzle for part 2 of chapter 10. So good luck. Please inquire. Please keep up with your readings, and I will see you on the next one.